Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, as you know, we're shooting these videos out every once in a while. It's kind of our little prediction series on what do we anticipate might happen during the 2023 legislative session. We try to take a look at the news and read the tea leaves, if you would, to figure out what new and creative ways your legislature might come up with disarming you starting January 9th of 2023 when the legislature gets back into session. Well, as usual, I have more bad news, so we're going to have to spend a few minutes today and talk about how they will try to do away with state preemption. Okay, before we get going down the road we are going down, proud to announce that this video is being brought to you by Security Gun Club. That's right, Washington's nicest indoor range, Security Gun Club, is found in Woodinville, Washington. Now, listen, check this place out. You will not find a nicer indoor facility anywhere in this state. But listen, there's a couple things that actually exceeds the facility. Number one, Tom and everyone over there has absolutely put together the best, nicest, most professional staff you will ever find anywhere in the business. So please stop by and tell them I said hi. But the thing that I'm most proud about my relationship with Security Gun Club is their dedication to education. You see, Jackson, the head of training over there, has developed a curriculum that's going to cater to anybody of any skill level, of any need. So whether you're brand new to firearms or you've been around firearms your whole life, whether you want some classroom instruction, group instruction, or individual instruction, Security Gun Club has what you need. Listen, for more information, visit them at securitygunclub.com. Now, that's not a misprint. That is security with an E. Visit them once again at securitygunclub.com. Okay, so what are we talking about today? Well, we're talking about RCW 9.41.290, the state preemption law. What is state preemption? Well, state preemption is much more important than most people give it credit for, because what it basically means is that the state of Washington gets to set our firearms restrictions. Now, I know none of us are thrilled about the state of Washington setting our firearm restrictions. However, especially for those of us here in the Puget Sound region, can you imagine if the city of Seattle set your firearm restrictions, or the city of Edmonds, or the city of Tacoma, or the city of Bellevue? Okay, now I'm sure if you live in the city of Yakima, the city of Pasco, the city of Walla Walla, you're probably not as concerned about it. But the most important thing about state preemption laws is that for all of us in the lawful and responsible gun owning community, we just simply want to know where the lines are so that we can color inside of them. And the importance of the state preemption law is that what is unlawful in Spokane County is also unlawful in Grays Harbor County and everywhere in between. And what is lawful in King County is also lawful in Yakima County or Chelan County or Okanagan County. And that uniformity is important to how laws are implemented and enforced. Now, as we know, last legislative session, there was Senate Bill 5568. It really didn't get off the grounds because they were working more feverishly on other ways to disarm you. But 5568, had it become legislation, would have allowed municipalities suddenly the right to set restrictions about where you could or could not carry firearms. Now, under the current state preemption law, the law reads like this. The state of Washington hereby fully occupies and preempts the entire field of firearms regulation within the boundaries of the state, including the registration, licensing, possession, purchase, sale, acquisition, transfer, discharge, and transportation of firearms or any other element relating to firearms or parts thereof, including ammunition and reloader components. And there's some limited exceptions with the state preemption law, and those read as follows. Cities, towns, and counties or other municipalities may enact only those laws and ordinances relating to firearms that are specifically authorized by state law, as in RCW 9.41.300, and are consistent with this chapter. And then in RCW 9.41.300, which is a statute which lists all the prohibited areas that we can't take firearms, they list certain exceptions. For example, cities and municipalities can limit where a person can discharge a firearm as long as it does not infringe on a person's ability to defend themselves. They can also limit possession of firearms at sporting venues, concert venues, and things like that, but those restrictions cannot apply to those who have valid concealed pistol licenses, and they can restrict the zoning of gun stores and things like that, but they cannot restrict it any more conservatively or prohibitively than any other industry in that same category. So with those limited exceptions, for the most part, we kind of know what rules apply to all of us regardless of what city or county we are in the state of Washington. However, we now have mayors, Bruce Harrell, for example, out of the city of Seattle. After the Uvalde shooting, he suddenly felt the need that Seattle needs to have its own gun laws. In fact, he was quoted in the press as saying, "In Washington, because of state preemption, cities are nearly completely prohibited from passing our own laws to keep our communities safe from gun violence. This must change. Cities and towns across our state need to have the freedom to enact laws that reduce gun violence, particularly now as shots fired and shooting deaths are spiking." And can you imagine the type of gun laws that the city of Seattle would implement? Now, let us remember that the city of Edmonds, several years ago after the Marysville-Pilchuck shooting, decided that they were going to implement their own safe storage provisions, which were more restrictive than those found in RCW 9.41.360, which is our state safe storage provisions. And when they passed that law, as the paper put it, the city of Edmonds tried to take gun control into its own hand when city lawmakers passed a requirement 4 years ago that all guns in the city be safely locked and stored. The National Rifle Association and Bellevue Second Amendment Foundation fought the legislation in court, and eventually the state Supreme Court ruled against the city. And that is one of the most gross mischaracterizations about what actually happened here. And so candidly, shame on you, Q13, okay? Q13 Fox, that's where this story came from. It was not that it was eventually overturned by the Supreme Court. Here's what actually happened with the city of Edmonds. You see, when they passed that law, then yes, the Second Amendment Foundation immediately sued for an injunction in Snohomish County Superior Court, not the most conservative court on the planet, by the way. And the injunction was immediately granted. So then the city of Edmonds appealed to the Court of Appeals, Division 1, a 3-judge panel, and the city of Edmonds lost 3-0. So far they're 0 for 4. But no. The city of Edmonds wanted more. They wanted more. They wanted to waste more of their taxpayers' dollars. So what do? They appealed to the state Supreme Court. Now, no one is ever going to accuse the Washington State Supreme Court of being Second Amendment friendly or particularly conservative. What was the ruling there? Oh, it was 9-0 in favor of the plaintiffs in that case. So to suggest that the Supreme Court eventually ruled, no, the city of Edmonds lost miserably at every stage of the proceeding. Okay, now Tacoma Mayor Victoria Woodwards, she wouldn't go as far as Mayor Harold, but you can see what she's saying, because she's quoted in the same story as saying, "If I were being honest, if the state did its job, we would not have to count on local government to do it. The federal level should be responsible, but when they are not, please give me the opportunity to be able to make the laws to keep my community safe." Yes, similar to the ammunition tax that you passed that's had absolutely zero effect on safety, and similar to the ammunition tax that the city of Seattle passed that's so cost prohibitive you literally cannot buy ammunition in the city of Seattle, but I don't see crime statistics going down. So listen, the bottom line is they are beginning to pound this drum. We already had previous efforts to do away with state preemption, and we will see a much more feverish effort to do so this year. We're beginning to see the mayors, we're beginning to see some of the county councils, we're beginning to see a lot of local governments screaming for this. And the political pressure on the left will be there that, yes, they are going to go try to gut RCW 9.41.290 and some of the exceptions in 941.300. Can you imagine allowing the city of Seattle to regulate its own firearms? Listen. You may have more questions about what's coming this next legislative session or anything else, what's left of your Second Amendment rights. And if you do, remember, you can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.